quickly on that, anybody can, if you have a need for spousal maintenance, so you've separated, maybe you are heavily reliant, on your partner to support you. So you have a need, you establish you have a need, and then you have to establish that the other party has a capacity to pay. So obviously they have to look after themselves, they have their own sort of expenses. If you can establish a need, and you can establish that they've got a capacity to pay, the court will make an order for spousal maintenance. It's generally a more of a short-term thing. I think you're not going to have spousal maintenance for a very long period. It's designed to sort of help. It's probably very appropriate in the short term when children are young, and then as the children get older, both parties are encouraged to sort of find work and support themselves. Probably an appropriate period would be to allow time for a party to gain the necessary training to actually move back into the workforce. That would be an appropriate period for spousal maintenance.
When can spousal maintenance take place? Is the date of separation?
You can actually get spousal maintenance while you're still married, funnily enough, but de facto it has to be after separation. Most people get it after separation, but if you're married, you can apply for spousal maintenance during marriage. So you can apply for it straight away. But obviously you have to probably establish, I suppose it's looking at it practically. If you're asking for spousal maintenance, then obviously you're not living with your partner and you're struggling to survive. So you are separated in effect. So I think it'd be very difficult for you. Well, I can't see too many situations where someone would be asking for spousal maintenance while they're still married. But in answer to your question, David, it can be any time, but generally it's after separation that you would apply for it. I had a case recently actually where, quite a sad case, where my client has multiple sclerosis and she's just separated from her husband. And we negotiated quite a good settlement where she's getting the whole of the house rather than 50% or 60%. But even in that case there, she wanted to give up any right to spousal maintenance. And I sort of thought, because she doesn't have a job or anything, and her condition is getting worse and worse. And I was very cautious. I said to her, look, you really can't do this. But she wanted to end the whole thing. She wanted to walk away. She didn't want to have anything further to do with her former husband and family law proceedings. But that's a case there. When somebody's got an illness, they're a walk up. It's a lay down misere that you're going to get spousal maintenance because. When you get married, there is the whole base of the Family Law Act is that you get married with the intention of making it, forever.
Forever.
Forever, that's right. So even though the court's like, well, yes, you can separate and you can go your separate ways, we've got no problem with that. But there is still that sort of that paternal sort of overriding consideration that we're going to make sure that you're looked after in the future. And that's why when I talk about Section 75(2), which is welfare factors, that's another step after contributions. So contributions are, what have you put into this marriage? What have you contributed? Then you should take that back out. But once you've done that, they still look at the 75(2), which is the welfare factors, which is like that, same as spousal maintenance, like what do you need to be looked after? You need to be looked after for the future because, as you made that point, when the Family Law Act was first enacted, it was, it was on the basis that the views of society, and I think there's still the views today, that when you get married, it's a commitment for life, that we all intend for it to last for life, even though, we make mistakes and we're entitled to make mistakes.
This is a two-way street. A husband can ask it of a wife as well.
Yes, that's correct.
Mm-hmm.
Absolutely.
Excuse me.
Yes?
Are there cases you've handled that the final separation did not push through and they reconciled?
No, I can't say that I've heard of it, but I'm sure there are cases like that. Actually, I can tell you one case. I saw a gentleman who actually separated from his his wife after 20 years, and then he entered into, I think he entered a financial agreement, and he agreed to give her one property and he would take another property. The agreement wasn't very much in his advantage, but he was advised about it, he agreed to it and everything. And this was back in I think it was 2000 it might have been. And then following that, they still lived in the same house. So they got divorced, but they stayed living in the same house. They had 2 young kids, they stayed, actually I think they were probably in their early teens at that time. They stayed living together, and they really stayed together as husband and wife. They still went to parties together, they still told everybody they were still husband and wife. And it was sort of a strange relationship because they sort of stayed together for another 10 years, and then his wife met somebody on the internet and then decided she wanted to go actually really leave him this time. So she said, okay, I'm now really leaving you, and he came to see me about what to do, and it was really quite bizarre because he had this previous agreement which I thought wasn't really in his interest, but they hadn't actually swapped over the properties, they sort of kept them there. It was really quite strange. And then he came to me and he said, okay, she's now leaving me, we've got to do it again. And so I went to draft another agreement for him, but I sort of had to, we sort of had to disregard the previous agreement because it really never went into effect, it sort of got glossed over. And anyway, what happened is that she went overseas to meet this gentleman she met on the internet, and apparently he called it off and she came straight back and then decided she was still in love with him, so they're getting back together. So yeah, there you go. So it does happen. It does happen.
Good for a movie.
Yeah, that's right, absolutely. Okay, so this is just a bit more about spousal maintenance. So the things they look at is your age and health, your income, property and financial resources, your ability to work, what is a suitable standard of living. People always, some people who've been in quite good marriages and they've had, enjoyed maybe they had a very high standard of living, and the marriage terminates and they want to get spousal maintenance and they think, well, I need $3,000, $4,000 a week to keep living this lifestyle. And there's always a bit of a question about what is reasonable, like what should the court actually, what should they consider as something that, if the husband's got the money or the wife's got the money, then, what would be a reasonable standard of living? Look, I think it really depends on the circumstances once again, but I think that you have to use common sense. I don't think, it's not really appropriate for somebody to receive quite the level of assistance they might have got before if it's well and above what they really need to survive. I can't tell you exactly. I think what I can say to you is that it's basically the test is what is a reasonable standard of living. So you're not supposed to live hand to mouth, like in a real basically in a type of sort of what is just your necessity. You are entitled to have a reasonable standard of living, but nothing too over the top. And spousal maintenance too is something that the court, I think, really considers to be a temporary thing. It's really designed to sort of help parties until they can move to that final stage where they have finally divided up the assets and gone their separate ways. The whole idea of the Family Law Act is to try and bring a resolution to all these things. They don't want the parties sort of, involved in ongoing disputes in court and to be tied up, particularly when they have decided the marriage is over and they want to go their separate ways. It also takes into account children under 18 years of age or adult children who are disabled can be taken into account. Okay, this is pretty much all it. I just put a bit about alternative dispute resolution. We've already talked about the less adversarial trial process. I've talked a bit about mediation and conciliation. The top one, collaborative law. You may or may not have heard of this. We are encouraged to discuss it with clients. Essentially, collaborative law is a process where you go and see a lawyer. You have to see a lawyer who does deal in collaborative law. Not all lawyers do that, but essentially, what the whole it's a system that's come over from Europe really. what the whole idea is that you and your partner and your respective lawyers enter into an agreement where effectively you try and resolve the matter, and if you can't resolve the matter, and you want to go to court, your lawyers cannot represent you anymore. So effectively the lawyers enter into an agreement that they will go no further if you cannot settle your case. Now, I think the whole idea about that is that it's going to get everybody really focused on trying to settle the case, so you know that might be, depending on your opinion, that might be a good way to come to a resolution. But there are lawyers out there that really are strong advocates for this process, and I think everybody should be aware of it. There's a process out there. Not all lawyers practice in it. I have not had any experience to deal with collaborative law, which doesn't mean that I wouldn't try it. You know, if I had a client that wanted to get involved in it, I'd certainly give it a go. It's basically, it's really like, I suppose, an extended mediation process. You know, you enter into this agreement, and you have ongoing meetings in an office. You either pick the other lawyer's office or your office, and the parties just keep meeting in this office, and you just do everything you need to do. Like you exchange documentation, you create balance sheets. You know what your assets and liabilities are. You talk about you know who's made what contribution. It's usually it's encouraged to be a round table, so everybody's. And also the lawyers and the parties have you know, have an opportunity to speak, so everybody gets a chance to sort of, you know, express themselves. Nothing that gets used in these proceedings can go to court. It's all confidential. So as you can see, it's sort of very similar to what I was talking about with the less adversarial trial process. You know, it's about getting people into an environment where they can nut out you know, a settlement. And as I said, if one person puts their hand up and says, no more, I'm out of here, I want to go to court, then that's the end of it, and both those lawyers no longer represent those parties. So, I mean, I don't know, if you're cynical and you think lawyers are all only interested in going to court, then you might think that's a great idea. I mean, from where I stand, I think lawyers still try to encourage settlement. But in any event, if we forget about that one part of it, I think the good bit about it is that you actually have this ongoing meeting in a room where parties are actually actively talking and trying to resolve it. So that's something that is, it's still relatively new, but it's something that's available to people and they should be aware of it. So yeah,